Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Have you ever wondered what makes a truly breakthrough idea patentable? Especially, when it involves something like digital payments or software, things that are everywhere now. Today, we're really getting into a landmark legal battle from India that's kind of reshaping that very question.
Yeah, this is a really interesting one.
We're talking about the recent Delhi High Court ruling in the Comviva Technologies Limited versus the Assistant Controller of Patents and Design case. Our mission here is simple. Unpack how this ruling clarifies the pretty muddy waters around software and FinTech patents.
Absolutely.
And reveal why it's a crucial shift, maybe even a global indicator. We've gone through the court judgment, legal analyses, the timelines, all to bring you the key aha moments.
And what's fascinating, I think, is how this case just shines a light on this ongoing challenge, globally really, of applying old school patent law to, super fast-moving digital tech.
Right.
Patents are meant to protect innovation, but what even is an invention anymore? That definition is constantly being tested, especially in FinTech, where business and tech are so tangled up.
So it's not just about Comviva then?
Not at all.
Yeah.
It sets a precedent, potentially, for every innovator out there trying to protect their technical solutions in this digital economy.
Okay, let's unpack this, the basics. So you've got Comviva Technologies Limited. They're the ones appealing. They have this idea, this patent application for making electronic payments safer using electronic tokens.
Right.
And on the other side, the respondent is the Assistant Controller of Patents and Design, the authority that initially said no, not patentable.
The gatekeepers, so to speak.
Exactly. And the decision came from Justice Amit Bansal at the Delhi High Court. That was November 12, 2024.
And the case number, just for reference, is CA-COMM.IPD-PAS 492-2022. But the timeline really tells a story here.
Yeah, walk us through that. It shows their persistence, right?
It really does. So Comviva files way back on January 4, 2016. This is for their methods and devices for authentication of an electronic payment card using electronic token.
Okay.
Then jump forward quite a bit, June 17, 2020. The Patent Office issues the first examination report, the FER. And here come the objections.
The big ones.
The big ones. Lack of inventive steps, sure, but crucially, non-patentability under Section 3K of India's Patents Act. They labeled it a business method and a computer program per se, both excluded.
Ah, the Section 3K hurdle. That's central.
Absolutely central. So after some back and forth, August 25, 2022, the Assistant Controller makes it official. Application refused. They double down on 3K.
Ouch. So Comviva appeals.
They do. December 15, 2022, they take it to the Delhi High Court.
And that leads us to the decision we mentioned.
Exactly. November 12, 2024, Justice Amit Bansal delivers the judgment, sets aside the refusal, says it is patentable.
Whoa.
And now, as of December 12, 2024, the case is back before the Patent Office, listed for the actual grant. So a long road, nearly 9 years from filing to this point.
So it all really boiled down to that Section 3K, didn't it? That part of the law defining what isn't an invention.
Precisely. A mathematical method, a business method, or a computer program per se, or algorithms, those are listed as exclusions.
So the court had two main questions to tackle. Was Comviva's invention just a business method? And was it merely a computer program per se?
Those were the exact legal battlegrounds. You had the controller arguing yes to both, hence refusal, and Comviva saying no, arguing their invention was fundamentally technical.
Okay, let's hear the controller side first. Why did they call it a business method?
Well, their argument was pretty straightforward on the surface. They said, look, this invention is directly tied to commercial transactions. It's about making electronic payments secure.
Seems reasonable enough at first glance.
Right. They felt this main contribution was helping financial transactions, building trust, aiding business growth, classic hallmarks, they argued, of a business method. They even pointed to the CRI guidelines, Computer-Related Inventions Guidelines.
Ah, the guidelines.
Yeah, Clause 4.5.2 specifically, which says if the core subject matter is essentially about carrying out business, Well, it's a business method.
Mm.
And they saw words like payment, transactions, financial transaction in Comviva's claims and thought, case closed, business method.
Okay, so that's the business method angle. What about calling it just a computer program per se? What was the thinking there?
The controller basically said the actual novelty, the inventive part, is only in the software code that performs the electronic payment steps.
Just code.
Just code, in their view. They didn't believe the invention described any real technical interaction beyond just automating a process, even with servers and mobile devices involved. It was like, you're just telling a computer what to do for a business task. No patentable technical core.
Right. So that sets the stage perfectly for Conviva's counterattack. How do they push back? They must have really emphasized the tech.
Oh, absolutely. Their core argument was that the controller completely missed the point about technical effect or technical contribution. They argued that any computer-related invention, even one using software, is patentable if it delivers that technical effect.
That sounds like a key principle.
It is. And then they made this really crucial distinction. They said, look, our invention isn't about the financial transaction itself. It's about the authentication of that transaction.
The step before the money moves.
Exactly. They stress that this technical authentication process is completely finished before the actual financial part even kicks off. That separates the tech from the commerce.
Okay, that's a clever distinction.
Yeah.
Did they elaborate on the technical process itself?
They did. They laid out how it was a clear technical process to secure authentication. It involved an electronic token, communication with the payment card, all managed by a server. They described this whole system, a mobile device, a server, the contactless card, and the merchant's device as a multi-component, two-step security verification setup.
So it wasn't just software, it was a whole interacting system.
Precisely. A system designed to prevent unauthorized transactions. And that led to their final big point. They weren't solving a business problem, like how to make more sales. They were solving a technical problem, how to make transactions secure.
Addressing a technical vulnerability.
Exactly. They specifically mentioned overcoming the weaknesses of things like OTPs, one-time passwords, which, can be intercepted or seen if your phone's cloned or someone's looking over your shoulder. Their token system was presented as a concrete technical solution to those security flaws.
Okay, so the arguments are laid out. Now the moment of truth, Justice Bansal's decision. How did the court actually break down the controller's reasoning? This seems like where the real shift happens.
It really is. The High Court's ruling was crystal clear. It set aside the controller's refusal and flat out directed the Patent Office to grant the patent.
Wow, so why wasn't it a business method in the court's eyes?
The court leaned heavily on those same CRI guidelines the controller cited, but interpreted them differently, specifically Clause 4.5.2 again. The court clarified, just because you use words like payment or transactions doesn't automatically make it a business method if the invention specifies an actual apparatus and/or a technical process.
So substance over keywords.
Exactly.
Yeah.
The court found Comviva's invention wasn't aimed at a business problem, but specifically at the security of the transaction. The inventiveness, the clever part, was in the technical process, not some new business strategy.
And that timing distinction must have played a big role.
Huge role. The court really hammered that point. The authentication, the core technical invention, finishes before the commercial transaction starts. That cleanly separated the technical security part from the business activity.
Did they reference other cases?
Yes. They cited OpenTV Inc., the controller. That case reinforced the idea that you have to ask, is the invention trying to monopolize a way of doing business, or is it a computer program producing a genuine technical effect or technical advancement? The court concluded Comviva's invention was definitely the latter. The controller, they said, basically overlooked all these critical points just by focusing too much on the terminology.
Okay, so the business method argument dismantled. What about computer program per se? How did the court handle that?
Here, the court went back to another landmark case, Faridalani v. Union of India. This case established that the ban in Section 3K is on patenting computer programs per se, meaning like the raw code itself, the abstract instructions. It's not a ban on all inventions that happen to use computer programs.
Yeah, the per se is doing a lot of work there.
It's doing all the work. The court stressed that this decision reinforced the principle. For computer-related inventions, the key is whether they produce a demonstrable technical effect or technical advancement.
So using a computer program doesn't automatically disqualify an invention?
Not at all. The court called denying patents, just because code is involved, retrograde. especially now when almost everything involves software cars, phones, AI, blockchain, you name it.
Makes sense.
That, per se, was put in the law deliberately, the court argued, to make sure genuine technical inventions that are implemented using software aren't unfairly excluded.
So how did Comviva's invention meet that technical effect test?
The court found it clearly provided a technical solution to a technical problem. It improved security in contactless payments, tackling known vulnerabilities of things like OTPs. The whole system, the token, the proximity check, the encryption, the multi-layer verification, was seen as a definite technical advancement. The controller just failed to see that technical contribution.
Okay, so the refusal was overturned on both counts. This feels pretty significant. What does this ruling actually mean for innovators, for people listening, for the whole digital landscape? It sounds like more than just one company's win.
Oh, it's definitely more than that. This decision has real legal and precedential weight, especially for computer-related inventions, CRIs, and FinTech patents in India. And importantly, it brings India's approach more in line with global standards.
How so? What's the main takeaway?
The biggest takeaway is that it strongly reinforces a narrower reading of Section 3K. The exclusions for business methods and computer programs per se aren't absolute brick walls. The real focus has to be, does the invention offer a technical process or solution? You can't just dismiss it because it uses business-related words.
And specifically for FinTech.
It sets clearer guidelines. By drawing that line between the financial transaction itself and the technical process to secure it before it happens, it really opens the door for patenting security innovations in digital payments. That directly tackles real-world security issues in things like contactless payments.
So it validates the importance of the technical effect test.
Absolutely. It firmly cements the technical effect and technical contribution tests as the main way to assess these inventions. It builds on Faridolani and aligns with how places like Europe handle this.
Does it change things for the patent office examiners too?
It should. It's a strong message to them. Look beyond just keywords. You need to do a holistic examination. Look at the substance, the technical process. Does it actually solve a technical problem or offer a technical step forward? It corrects what the court saw as the controller's previous overlook.
So overall, a more positive environment for software and digital tech patents.
Yes, definitely more clarity and a more inventor-friendly stance, provided the invention offers a genuine technical solution, even if it operates in a business or financial context. It really shows the courts trying to keep patent law relevant in the digital age.
This deep dive really brings home a crucial aha moment, doesn't it? The actual substance, the technical contribution of an invention, should win out over a really narrow, literal reading of the law. It feels like a clear signal, especially for innovators in tricky areas like FinTech. If you're solving a real technical problem with a technical solution, there's a path to getting that protection.
Exactly. This case is a great reminder that patent law has to evolve alongside technology. It's not just about the words you use in your claims, it's about the core technical problem you're solving and the tangible technical effect you're creating.
Right.
And that leaves us with something for you, the listener, to think about. How could this ruling spark a new wave of innovation? Ideas that cleverly weave technical solutions into business frameworks, pushing the boundaries of what we even think is patentable. How might that change how we live and interact digitally?
Yeah.
What really stood out to you from this whole case? Maybe think about how this decision challenges your own ideas about innovation and how we protect it in this increasingly digital world.
That's a great point to end on. That's all the time we have for this deep dive. Thanks for joining us on this journey to get better informed, one key insight at a time. Until next time, keep digging deeper.